Welcome to the University of Toronto Joint Centre for Bioethics Seminar Series. I'm Angel Petropanagos, and I'll be the moderator for today's session. Our speaker today is Trudo Lemmens, and his seminar is entitled When Medical Assistance in Dying Becomes a Terminal Therapy for Suffering in Life, Critical Reflections on Canada's New MAID Bill. Before I introduce today's speaker, I'd like to let you know that the seminar is being recorded. This lecture, along with other archived lectures, can be accessed through the Joint Centre for Bioethics website. The format of our seminar is a presentation by our speaker, followed by a facilitated discussion period. Please add your questions in the YouTube chat. We would like to take a moment to acknowledge this land on which the University of Toronto operates. For thousands of years, it has been the traditional land of the Huron-Wendat, the Seneca, and most recently, the Mississaugas of the Credit River. Today, this meeting place is still home to many Indigenous people from across Turtle Island, and we are grateful to have the opportunity to work on this land. We also stand in solidarity with the ongoing protests against racism and systemic discrimination. Now, it is my pleasure to introduce today's speaker. Trudo Lemmens is a professor and Scholl Chair in Health Law and Policy at the Faculty of Law, the Joint Centre for Bioethics, and the Dalla Lana School of Public Health at the University of Toronto. His research focuses on the interaction of law, governance mechanisms, and the ethical norms and values in the context of healthcare, biomedical research, and health product development. His publications appeared in leading journals of law, science, medicine, health policy, and bioethics. He has written and lectured extensively on medical assistance in dying, particularly on the developments in Canada, Belgium, and the Netherlands. He was a member of the Council of Canadian Academy's expert panel on the topic, an expert witness for the Federal Attorney General in the Trudo case, and testified before Parliament during the drafting of the current law. And he can be followed on Twitter at Trudo Lemmens. So Trudo, over to you.
Thank you, Angel, for the kind introduction. It's really a pleasure to talk to you. It would have been nicer in person that I would see also people who can directly ask questions, but we do what we have to do in the context of the pandemic. I will make comments about the bill. I will not give too many details about what the bill will propose. I will actually focus on some of the broad changes that, in my view, will be taking place in the bill. So I don't have slides. I have a text that I will that I will read and talk around, and then we can open it up for questions. So let me start by sketching what will happen if Parliament gets what it wants, if Parliament goes along with the government plans. Canadian doctors in our medical system will soon be able to offer a new form of therapy to many more people who experience unbearable physical or physiological suffering, actually. This is the language used on the government's website. While until now only available to people like David, 65 years old, who suffers from terminal cancer, the new law would offer the therapy to people like Teresa. At 25 years of age, she has spinal cord injury from a bike accident, has been in and out of hospital, struggling with complications from various operations. Or to John, 60 years, who is faced with increasingly serious epileptic seizures. Or to Uma, 55, whose diabetes is very hard to control and who has trouble submitting herself to the regime that diabetes requires, who is facing the prospect of an amputation of one of her limbs. Unlike other pharmacological therapies, which may not always be affordable or they may be very expensive for people who don't have a private additional healthcare plan, this therapy is covered across Canada by the healthcare system. And unlike some other therapies that may only be available as a secondary choice or as last resort when first-line therapies appear ineffective, this therapy will be available when people want it. John, Teresa, and Uma will be asked to consider other options, and this consideration or the seriousness of this consideration will be verified by an assessor. They have to be well informed, but if they refuse some or all other forms of therapy, they will still be eligible for this one. They will also be submitted to an assessment period which is part of this consideration, which will focus on looking at various factors that may contribute to their choice for this therapy. And this assessment period should take a minimum of 90 days, which can, however, be shortened if assessments are completed and loss of consciousness is imminent. If this is all good news, there is more. The therapy, unlike any other form of medical therapy, is about or close to 100% effective and fail-proof. Not surprisingly then, that the government confidently states that it will, quote, reduce unnecessary suffering in Canada. If framed this way, who can disagree that the new bill to expand medical aid in dying, or MAID, is the most fantastic improvement our healthcare system has seen in the last decades? Expanding this therapy outside the end-of-life context appears an uncontestable improvement. We should perhaps thereby forget that the name for the procedure, medical aid in dying, which suggests that it is a method to assist in the process of an already occurring natural death, is no longer really appropriate, which has been emphasized by several people, including the Joint Center for Bioethics, Alex Campbell. People are already used, however, to the acronym MAID. So who cares that we're stretching the original meaning of the term and simply now refer to the practice as MAID? The only problem with the bill so framed is that this view that it doesn't go far enough. It explicitly excludes people whose sole underlying condition is mental illness, and some may also feel that the therapy isn't offered fast enough for those outside of the end-of-life context who are not close to death and who want to have access to the therapy. Those who have read the abstract of my presentation and who know some of my work on this realize that I'm not presenting here my views on the bill. I use here the terms and rhetoric the government embraces and framed expanded MAID as another standard medical practice, as many suggest we should do. Framing it this way clarifies in part why proponents of an expansive MAID regime have been so successful. It becomes an uphill battle to call for caution, to point out some risks, and to call for humility when we make claims in the context of medical care about our ability to solve the suffering many people face. When physician termination of the life of patients is presented, if it were another form of medical therapy, one that can be prioritized because of how clearly effective it is in solving irremediable suffering. So that's why it becomes an uphill battle to point out these risks and to call for caution. And it also is so when we thereby obscure or trivialize the fact that it also means the end of any experience, since it annihilates people's existence. What also contributes to the perception of MAID as an overwhelmingly positive healthcare development is the way that two ethical foundations have been interpreted and used in this context. Autonomy, with the right to make self-regarding decisions at the end of life, and the need to relieve suffering connected to beneficence. Each of these two concepts are given a very acontextual meaning in this debate. Autonomy is largely reduced to choice and detached from the complex socio-economic, professional, and healthcare context in which we make our decisions. And suffering is viewed in this debate often as entirely subjective, in particular individually determined, without acknowledging the various factors that contribute to perceptions and experiences of suffering, or the complex ways in which socio-economic, healthcare, spiritual components interact with and contribute to our suffering and our ability to cope with it. So in other words, we see a view here of suffering as I decide, and MAID as I decide whether I want to have MAID because of my suffering. My suffering is an entirely individual experience. These two concepts are also interchangeably used in the debate, depending on the arguments that need to be made, and nearly inevitably in support of the most open access to MAID as therapy. When critical questions are raised about the need for safeguards, to ensure meaningful autonomy and real informed and uncoerced choice, such as safeguards of repeated consent, 10-day reflection period, or more stringent evaluations of capacity for decision-making to make sure that people fully comprehend what is at stake. When these critical questions are raised and the need for safeguards is emphasized, the need to relieve unbearable suffering is often invoked to challenge these safeguards. If there is suffering, the argument becomes why all these measures that hinder access to medical aid in dying, why these delays? But when arguments are made that alternative avenues for relief of suffering are available and need to be explored first in order to help people to live, autonomy is invoked to reject those as paternalistic barriers. We see these patterns of alternating justifications shifting from autonomy to the need to relieve suffering in statements made by the government, particularly the Minister of Health, the Minister of Justice, actually. Let me put here to you, though, that there is a problem with that expanded view of MAID, which is that if we follow that approach, it is inconsistent with any limitation on medical aid in dying, and is also inconsistent in effect with identifying healthcare providers as those who need to be involved in providing this as a practice to resolve suffering. The current MAID bill, in other words, if you take that view to its logical extension, is way too limited. If autonomous, acontextual choice and a completely individualized notion of suffering are sufficient as a basis, why not just provide it to anyone who asks for it? And this, regardless of any form of illness and any medical cause that underlies the person's experience of suffering. If, as the government frames it, the new bill aims to reduce unnecessary suffering, why not just develop even a new profession outside of the medical profession, which can be called thanatologist, as some have suggested. We train them in obtaining informed consent, some basic measuring of the individual's experience of suffering, and make MAID universally accessible on the basis of demand and some measures of the presence of suffering. The reason why we don't propose this, I would suggest, is that this appears too dystopian, and even most proponents of a very open MAID regime don't want to portray that as an ideal. It comes uncomfortably close to movies like Blade Runner, where we see very individualistic survival culture and individual choice in a survival of the fittest. But it is also, this dystopian view is incompatible also how most people currently view the role of the medical profession, as well as the role of the state in prioritizing the best possible care to people regardless of one's age, disability, illness, financial means, and so on. Also incompatible with the view that we do value and promote the idea that people's lives are worth living. It appears, in my view, also incompatible with the values that are reflected in our Charter of Fundamental Rights and Freedoms. In other words, it clashes with our constitutional rights. I'll come back to that in a minute. Framing MAID as a medical practice makes expanded MAID more acceptable and also explains the significant buy-in, actually, of healthcare professionals, many of whom are often frustrated and struggle with the ongoing failure of medicine to offer solutions for our most serious diseases, and also struggle with the failure of medicine to help us cope with some of our most challenging human experiences, helping to cope with the inevitable level of suffering that we see around us. What those presenting MAID as patient empowerment, however, ignore is that framing MAID as medical therapy conveys more power to healthcare providers than ever before, the power to end the lives of their patients, even if it is on the basis of informed consent. And obviously, while it appeals to some professionals, this idea of power and a way to solve the suffering that is nearly incontestable, It is actually quite reassuring that many people feel also limitations to take up that power and to accept that this is the role they should be playing. The new bill, to come back to the bill, fits within this mode of thinking. It portrays MAID as a medical therapy for relief of suffering based on choice, which seems not to go as far as the dystopian view that I mentioned before. But without embracing the dystopian model, it moves, in my view, uncomfortably far in that direction. And most problematically so, only for one category of people, those who have a disability or are chronically ill. It does so by embracing an abstract notion of autonomy, an acontextual, individualized experience of suffering, and by confirming in law that health professionals need to accept that patients can insist to have their lives ended, even when there are clearly other treatment options available. And I want to emphasize that here. I would be happy to come back to that in the question period. I don't develop it further, but it's a very important point to make that Canada will be the only country in the world where it's explicitly stated that patients will be able to refuse reasonable options of care and still have access to medical aid and die. Healthcare professionals, in other words, are now asked under this new bill to accept that they have to act according to what they, in all other circumstances, would consider substandard care, namely providing a radical life-ending procedure when other procedures are available that they know can reasonably relieve the suffering of their patient. In other words, the medical profession, and it's interesting that the medical profession is not more up in arms about that. The medical profession hereby accepts that the law states that patients identify in this context fully what the standard of care means to them. I would put forward here in the remainder of my presentation that the bill, as proposed, is thereby also largely ignoring, or I would say maybe more prudently, paying only lip service to the values embedded, or some of the values embedded in the original law. And that it is thereby ignoring some crucial charter obligations the state has in protecting life, and to protect life in a manner that is non-discriminatory. The new law abandons, in my view, the balance the current law at least tried to achieve. Whether the current law, or particularly how the current law is applied, does so is another question. I can't answer that here. There are some issues with how the law is applied, but there is at least an attempt in the current law to balance autonomy over decisions about how we want to die with the protection and promotion of the right to live, and the protection of the equal valuing of life who are elderly, ill, or disabled, as well as their protection against premature death. The current bill abandons this balance, in my view. It does so by seemingly accepting, influenced by the Trudo decision, that there is a right to die, which the state has to enable, by ignoring the complex context in which healthcare decisions are made, by removing the protection against premature death that people who are not chronically ill or disabled continue to receive, and by thereby also reaffirming discriminatory stereotypes about the value of the life of people who are chronically ill or disabled. I cannot cover all of these points here in detail, and I will probably dissatisfy the legal scholars or the legal experts who are here listening, and I may lose some of the people who are not legal experts by some of the details I will provide, but I will, and I think it's important to do so, provide some discussion of the complex interaction of various charter rights, which would require normally more time. Let me put forward here simply some key points and then illustrate the key problem with the expansion the bill provides, and why it particularly violates the obligation of to protect the right to life and is discriminatory. So let me start with this. First, protecting the right to life remains a key obligation of the state under the current law, even after Carter. The role of the criminal law in protecting that right and putting required limits to third-party involvement in a person's death was recognized by the Supreme Court in the Carter decision. In other words, prohibiting a third-party involvement in someone's death is in principle recognized as a legitimate tool to protect the right to life in the Canadian context. The Carter decision didn't change that, and in fact, the Trudo decision should not have changed that either. It's not the existence of a prohibition that was invalidated by the Supreme Court, but the absolute nature of it. Second point that is important to emphasize, there is no, certainly no unrestricted, but there is even no clear restriction, nor no right, a clear right to die under the Canadian Charter. And this is not something that has been recognized by the Supreme Court. Legal scholar Corinne Miller, in particular from the University of Ottawa, has rightly emphasized in her doctoral dissertation in various publications that the Supreme Court explicitly refused to recognize in Carter that, and I quote, the right to life includes a right to die with dignity, or, quote again from the Supreme Court, the right to determine to take one's own life. This would have created a very concrete positive obligation for the state to provide it in many more circumstances. The Supreme Court did not recognize that as part of the duty of the right to life, or the obligation of the right to life. Instead, the court based its invalidation of an absolute prohibition on the right to make self-regarding decisions, the concept of liberty, and the right to security of the person. But that clearly limits the extent of the obligations the state has to ensure the availability of medical aid in dying, and it still keeps, or it still raises the potential clash between these rights and the obligation of the state to protect the right to life. Yes, to take Karen Miller's point, individual people can, in specific circumstances, waive their right to life, but it remains an important duty of the state to try to protect it. With autonomy as a key basis for the court's decision to invalidate an absolute prohibition, the need for clear and unambiguous consent, and the need to ensure that people can exercise real, meaningful choice and exercise meaningful autonomy in the context of their healthcare decisions becomes key. Context, as I will point out certainly at the end of my presentation, is thereby essential. Third point I have to make is that the right to equality, non-discrimination, was not a basis of the Supreme Court decision in Carter. There's no Supreme Court ruling that supports the claim that people are discriminated against by restrictions to accessing medical aid and die. And I'll come back to that later. In response to Carter, as we know, to complete my discussion of what we see as the balancing of charter rights in the context of medical aid and die, in response to Carter, Parliament adopted a law that tried at least to balance these various charter rights at stake, and it identified a set of complex goals of valid, and I emphasize it, valid criminal law-based restrictions on healthcare providers' involvement or third-party involvement in the death of a person. Not only the protection of vulnerable people against premature death was set forward as a goal of the legislation, but also the promotion of the equal value of the life of people who are elderly, ill, or disabled, protection, and the protection against suicide as a public health goal. The emphasis on the need to promote these values as an inherent duty of the state resulting from the duty to protect the right of life seems clearly opposite to the kind of far-going dystopian view that I sketched and that I suggest the bill is not necessarily embracing, but going towards. The view of the state as organizer of termination of life when people demand it is not something that is clearly reflected in the law and in the balancing that it tries to achieve. The law also reflects that the obligation to protect life has to be realized with respect of other important charter rights, including indeed the right to autonomy. So there is a balance to be obtained, but certainly also the right to equality and non-discrimination. You see that again, to emphasize, reflected in the need to promote the equal value of the life of people who are elderly, ill, and disabled. But indeed, didn't the judge in Truchon conclude that people with disabilities and chronic illness are discriminated against under the new law? Indeed, she did. And at least some of the reasons for doing so are worth summarizing here, because it shows, in my view, also why the government, in implementing or in putting forward a bill that builds so heavily on that notion of discrimination, embraces, in my view, a deeply flawed view of equality and the need to provide protection against discrimination. Justice Baudouin gave two reasons why the restriction to reasonable foreseeable death discriminates. The first reason, she said, was that it discriminates against people with chronic illness and disabilities who are not close to their natural death when you compare them to people with chronic illness and disabilities who are close to their natural death and who are receiving medical aid and dying as a form of relief of suffering. So people who are close to their natural death receive a privilege. People who are not close to their natural death, who still suffer from chronic illness and disabilities, just as Baudouin argued, are discriminated against. Discrimination also occurs, she says, between some people, not all, but some people with chronic illness and disabilities who may be physically incapable to end their own life, and those who are healthy and arguably capable of doing so. But that doesn't involve everyone. So her most important reason to say that the law discriminates is because it gives an advantage to people who are chronically ill and disabled, who are close to the end of life, and those who are not. Let me say something briefly about that basis, because it's a view that you see reflected problematically, in my view, in the bill. First, the Charter does not simply protect. I have to say something more about what actually the Charter protection against discrimination does. The Charter does not simply protect against differential treatment. It aims to promote a more complex vision of substantive equality, which may in fact require treating people differently to ensure that those who have traditionally been disadvantaged in society have access to the same goods, the same benefits, the same levels of protection than those who have been more privileged. To determine whether a legal provision discriminates then requires the courts to conduct, to quote the Supreme Court, a flexible and contextual inquiry into whether a distinction has the effect of perpetuating an arbitrary disadvantage. This tends to involve an investigation into broader social, political, economic, historical factors that show us why and how a particular group is being disadvantaged and how the law adds onto already existing disadvantage that these people face. Justice Baudouin recognizes that. I'm not saying that she takes a very, that she doesn't recognize the need for this more comprehensive view and the need to look at existing disadvantage. But her analysis of the potential impact on people with disabilities remains, in my view, problematically superficial. She does not at all explain, for example, how a restriction to reasonable foreseeable death adds to existing disadvantages people with disabilities who are not close to their natural death experience when you compare them, for example, what you actually have to do to those who are close to their natural death. I don't think that people who are at the end of life have traditionally been given privileges that reflect stereotypical, stigmatizing views of those who are not close to the end of their life. It's also important that she emphasizes that the restriction to reasonable foreseeable death perpetuates the stereotype that the physically disabled do not have the capacity to exercise decision-making autonomy over their body and their life, and that the restriction to reasonable foreseeable death, by stereotyping their inability to make their own self-regarding decisions, deprives them thereby of their autonomy. The problem is that people who are not disabled, don't have chronic illness, are also excluded from the same broad access to medical aid in dying. So it's not that there is a stereotyping of people who are chronically ill and disabled, that they're not capable of making their own decisions. Other people are also considered to be in need of protection against premature death in the complex context in which end-of-life decisions outside, not end-of-life, decisions about dying are made outside of the end-of-life context. In my view, it also fails to pay appropriate attention to the challenges, economic, social, and healthcare context in which people with disabilities have to make their choices. What's more important is that she thereby ignores the important goal of discrimination law to ensure that people who have a history of being discriminated against, for whom we can identify a pattern of existing discrimination also, are not deprived of benefits others receive in a way that reinforces, perpetuates, or exacerbates the disadvantage people with disabilities already face. Unless you see that as the most important good that people should inevitably and uncontestably have access to, it seems to me that a much more important goal of discrimination law clearly is that people with disabilities and chronic illnesses have access to the same benefits and protections others have access to, and which enable to live and to receive adequate healthcare, to live a life in dignity. I already stated before, in fact, that the Supreme Court did not recognize that there is a constitutional right to die with dignity or a right to determine one's own right as a component of the right to life. But on the contrary, protection of life is explicitly recognized as an important charter obligation of the state, reflected in the criminal law restrictions on MAID. What the new law now does is depriving people with chronic illness and disabilities from the protection others continue to receive, and in a way that reinforces stereotypical views of the value of life of people with disabilities and chronic illness as lives that involve unnecessary suffering. And you see me coming back here to this concept of suffering that is embedded in the notion of the need for MAID. A history of discrimination of disabilities, of people with disabilities in the healthcare context is precisely related to these stereotypical views, presumptions that their lives are not or less or no longer worth living, as we see reflected in often stereotypical views of healthcare decisions depriving them of the care others receive, or of people with disabilities being told under the current MAID regime already that a MAID would be a good option for them, even when they explicitly ask for better healthcare, or for example, in some specific cases that we've seen, better home care so that they can receive adequate support at home. It's also reflected in the problems people with disabilities often face with receiving DNR orders on their medical file without asking for it, in a lack of adequate accommodation that facilitates people with disabilities to have the same healthcare choices others have. If we go even more contextually, historically, it's reflected, and I know it's always controversial in the context of MAID to relate to that, but it's reflected in the historical instances of policies of sterilization, of being in Germany. It's hard not to refer to it, to the broader policies, euthanasia programs, of which were obviously different from the current MAID regime in the sense that they were programs of involuntary euthanasia, but they reflect at the same time a history of discrimination that has to be taken into consideration when we identify the need for protection against premature death. If anything, the pandemic has highlighted many of these direct concerns for people with disabilities. I can think here of how measures to curb the pandemic disproportionately impact on people with disabilities and chronic illness. They are most at risk under the pandemic, but have also suffered most from the cutbacks in services, pandemic isolation measures, indiscriminate exclusion of essential family caregivers from long-term care homes in a way that directly impacts on their right to life. I can also refer here to a debated, a contested, and I'm not going to enter into the details of that, but at least I can refer here to the concern that people with disabilities have expressed about pandemic triage policies and the way in which they risk to be deprioritized on the basis of certain perceptions of their quality of life and chances of survival. And I acknowledge here that in the Ontario context, there has been an attempt to include the voices of people with disabilities in the design of these policies. The most serious historical and current concern, in other words, for people with disabilities is that their fundamental right to life has not been respected in the same way as the right to life of others. The new bill does not address discrimination. It creates the most ultimate form of it when it deprives people of protection against the risk of premature death that others continue to receive. It does so by overly relying on a largely abstract notion of autonomy and on a view that reinforces the idea that the suffering associated with chronic illness and disability indeed is a reason to no longer wanting to continue to live. We don't say the same about the desire to die that somebody who is not chronically ill and not disabled may have in wanting to have access to medical aid and dying, because they won't have access to it. But obviously, I have to, and I've come here to the end of my presentation, there are safeguards, or there are restrictions, or there are attempts that have been made by the government to accommodate concerns from people with disability, from members of the disability community. The law has at least created a different track to access MAID for those whose death is not reasonably foreseeable, but as most important safeguard, a 3-month assessment period, which we should allow to explore social, financial, healthcare-related reasons why somebody who is not close to the end of life would prefer to die. I have 2 comments about this assessment period. First, the Minister of Justice has emphasized repeatedly that this is not a safeguard, that the 90 days may indeed be considered for some too long, suggesting in a way that it could be made shorter in the future. And the fact that he emphasizes so frequently that it's not a safeguard seems to reflect this strange obsession or this taboo around the idea that safeguards may be an appropriate thing to do when it comes to protecting the right to life. Statements have also been made by the government, particularly the Minister of Justice, in relation to these restrictions and safeguards, or to other restrictions and safeguards, which reflect a broader future agenda to expand further medical aid and dying, which in my view may put at risk further the duty to protect life. It also reflects the idea that this is only an assessment period and that the only aim is to really make sure that people are well informed and have considered other options, an extraordinary reliance on an atomistic concept of autonomy. The second big comment I would want to make is that the 3-month assessment period does not meaningfully prevent coercive circumstances from seriously impacting people's freedom of choice when facing life-changing challenges. Finding adequate treatment and support for chronic illnesses and disabilities is inherently complex, with the health and financial crisis caused by COVID-19 fueling and highlighting further concerns. When people are faced with life-changing illness or disability, it tends to take more than 3 months to have a renewed perspective on life. Some examples here that I can give, and I will limit them to just a few, put this 3-month period in perspective. I thank here particularly some students, Leah Krakovic in particular, for exploring with me various examples of what a 3-month period means in the life of people with disabilities. Just to give you some examples, the median wait time for access to specialized pain clinics was around 5.5 months in 2017 and 18, with some people waiting up to 4 years for treatment, making it faster to obtain MAID than to receive treatment for often debilitating pain. Recovery from spinal cord injury may not even begin within the first 3 months, yet a person who experiences such a life-altering injury, often accompanied by depression, could obtain MAID before crucial life adjustments and support start to provide hope. Many people with chronic illness or disability may need specialized long-term care, but people waited 126 days on average in Ontario in 2018-19 to have access to it. And more importantly, adequate home care, clearly preferable in the context of the pandemic, is not even available in several provinces. And access to adequate home care, as I already pointed out, has been a basis for some people to ask for medical aid in dying. Financial concerns may also influence MAID requests, but there again, we see that a review of Canada's pension plan disability benefit applications can takes approximately 120 days, with many people needing to appeal before obtaining benefits. The pandemic, which disproportionately affects people with disabilities, I already pointed out, and chronic illness, augments all of these concerns. Wait times for healthcare services, particularly mental health, have increased significantly. But many experts and the World Health Organization have warned about the devastating mental health impact of loneliness, social isolation, and reduced care on fragile elderly and other vulnerable people. Ontario's Minister, former Lieutenant General David Onley, Mayor Moran, and other colleagues have recently reported in a commentary how financial distress, or warned about how financial distress, loneliness, and isolation among people with disabilities seem to have pushed already some to ask for medical aid in dying. I have to stop here, but let me say that this picture that I gave you suggests that the government's proposed expansion of financial support for people with disabilities is indeed very welcome and absolutely needed. Measures to reduce wait times will hopefully be implemented soon, and serious measures to promote access to care are also needed. But in that context, introducing a social experiment with expanded medical aid in dying when people are more than ever vulnerable to the pressures of the healthcare and economic context in which we find ourselves is, in my view, not progressive policy making. It is, to a large degree, reckless moving forward with something which we don't know where it will lead. Let me say that there are also, a very, very final comment, that there are other problematic components of the bill that reflect, in my view, the same over-reliance on autonomy with a lack of recognition of the important, difficult context in which healthcare decisions are made, and a context which highlights how the state has a duty to protect life by not just relying on the individual choice, but also by creating particular safeguards that ensure that choices are made in a truly autonomous way and reflect real informed decision making. I think here particularly of the decision by the government to abolish the 10-day reflection period for people who are close to the end of life. Nothing in Truchon forces the government to do so, but introducing this abolishing or removing this requirement of a 10-day reflection period, precisely when also at the end of life context we are seeing decisions being made now in the context of the pandemic by isolated elderly, by people who are suffering from loneliness in homes when family members are not able to reach them, seems the opposite of what the government should be doing. I'll stop there because I realize I have extended my time significantly, and we still want to leave some questions. I certainly invite people also to send me an email so that I can answer questions in person. Thank you, Angel.
Great. Trudo, thank you so much for sharing your presentation. So as you said, we're now going to turn to our discussion period. So you can, questions can be answered in our YouTube chat. I'm going to give everyone a minute to do that. Okay. So we have our first question here from Dorothy Ann. They ask, Trudo, how does this new law compare to what is available to people in other countries, for example, Belgium and Holland, in regards to their MAID equivalent laws?
So the bill moves certainly in direction of the Netherlands and Belgium, in the sense that these are the only countries that actually provide medical aid and dying, together with Luxembourg, outside of the end-of-life context. But the bill goes, in my view, further actually than Belgium and Netherlands, because in Belgium and the Netherlands, there is an explicit requirement, at least on paper. I'm not saying that it means that people cannot refuse any form of treatment, but there is at least a requirement that doctors or physicians have to assess that there are no reasonable alternatives that available. So in other words, medical aid and dying is explicitly recognized both in Belgium and Netherlands as a last resort. In the Canadian healthcare context, under the new bill, MAID will have to be offered to patients with the requirement that patients have to have considered the other treatment options, but there is no requirement that they actually are used as a last resort. So I think this is a very, very significant change. And in my view, it seems hard to deny that it means that doctors who know, for example, that a particular treatment will in all likelihood provide relief of suffering to individual patients, that they still have to participate or refer a patient for a life termination. In my view, it constitutes an obligation to provide substandard care.
Okay, thank you. So our second question is from Tim. They say, according to the argument presented, there is a premise that calls for consideration of those that do not have a reasonably foreseeable death or intractable pain and their ability to access MAID. Part two, are you aware of any cases whereby one does not have an unidentified disability if foreseeable death can be considered a disability in wanting MAID?
I have to look on my screen the question more detail.
Yeah.
Aware of any cases where one does not have an identified disability in wanting MAID? People, that's a whole debate around rational suicide. People may give up on life. People may decide that they have no further reason to live. Is that associated with disability? Not necessarily. So in most cases, or in many cases, there may be an underlying medical reason to request the end of your life. The desire to die is often associated, obviously, with particular forms of mental illness, but not necessarily. So yes, in principle, there can be, and there are people who express a desire to die. This is certainly an ongoing debate, for example, in the Netherlands, where proposals have been made that a new form of euthanasia should be available for people who feel that their life, that they have fulfilled their life, that they have no longer any desire to live, even when there is no underlying medical cause for that desire to die.
Thank you. Our next question is from Richard. They ask if you can see a way that a law expanding access to MAID could address your concerns about discriminating against those with chronic illness and disabilities, or about the decontextualization of their suffering, or are your concerns just incompatible with expanded access to MAID?
It's a very good question, a very important question. I think the bill certainly doesn't go far enough in providing or ensuring that all safeguards are in place to avoid that people opt for premature death in the absence of therapy that may help them. I think there is a wrong prioritization taking place, particularly in the context of the healthcare and economic context that we currently face, but even more generally. I am worried about a law that explicitly identifies a group of people with chronic illness and disabilities as being in need of preferential access to medical aid and dying. So I think indeed inherently there is a form of stigmatization that is reflected in a bill that expands medical aid and dying or assisted suicide to particularly people on the basis of chronic illness and disability. So yes, I think that there is harm in the mere creation of that form of exceptional regime for people who are chronically ill or disabled. Can I imagine that there are circumstances, or can I think of individual examples of where people's suffering is so enormous that they actually don't see any way out? Yes, and I struggle with that. I don't have an immediate answer here. I would, with the person who asked me that question, want to sit down and kind of work ourselves through some of these scenarios. But my worry is that by finding individual cases that would fit that argument or that particular need, we forget about the broader systemic impact of legislative change that exceeds the interests of the individual. So I believe indeed that sometimes we may not have a reasonable solution, even when we think that in individual cases we sympathize with the fact that people would want to opt for MAID and it is not necessarily available to them. So I don't know if that answer is very clear. It's more about, yes, we can find individual exceptional cases where we may be tempted to think that there should be access to a particular procedure, but sometimes legislative changes can have such a broader, more systemic impact that we have to accept that we don't have a solution for all.
Thank you. So I do see that it's 5 o'clock, and I know we started a little late because of technical difficulties. So we are going to take another 10 minutes, if that's okay. So we'll have time for a few more questions.
Could I add one more thing to the last question very briefly?
Absolutely.
So one thing I would say is, and I know that people are working on this, to think about, how a monitoring system could look like. I actually think that the current law already fails in protecting people with disabilities and chronic illness from premature death by the very broad, expansive interpretation of reasonable foreseeable death. So we've seen already people who may have been suffering from severe depression, who were not close to their natural death, but who, under an expanded view of medical aid and dying, have been provided access to medical aid and dying. I think even with the current bill, there are better monitoring procedures that we can put in place to ensure, for example, that there is an assessment of the social circumstances, potential financial pressures, better mental health assessments, making sure that all other options are explicitly made available to the person, including the best possible palliative care or other forms of care. So it doesn't have to be, with palliative care, I'm not taking the position here that palliative care only exists really at the very end of life. Palliative care is a much broader concept. So I think there are measures to be put in place that reduces the risk. But I think when you start going beyond the end of life, you are clearly dealing with a much more significant risk that we're giving up on people who may have years or decades to live, and at the same time systematically stigmatizing actually people with disabilities by the implementation of such a regime. So I'll stop there.
Well, so our next question is actually a comment. So this might give you an opportunity to further expand on some of these thoughts, particularly your final comments in your presentation. So Anna comments that there's a 20-year wait list for adults requiring assisted living for persons with developmental disabilities in Ontario. I just wanted to give you an opportunity to speak to that if there's anything you'd like to add.
There's 20-year wait list for adults requiring assisted living for persons. So I would say, thank you for the example. If anybody here on the call has specific reports with examples of wait times and that really can impact on the quality of life of people with disabilities, I'm looking for more examples to use in articles where I highlight actually that even the improved financial means that the government is proposing to people with disabilities is clearly not enough. I mean, there are fundamental problems of providing adequate quality of life to people with disabilities, and offering MAID in a way that it becomes so easily accessible that after an 90-day evaluation period, when compared to a 20-year wait list for assisted living, I think it's a stunning example of the wrong prioritization. Let's also not forget that simply implementing, because the government recognizes that there are risks associated with medical aid in dying, that medical aid in dying is not just as any other form of therapy. So there's something contradictory also about that. It does recognize in all of its statements that there is at least some need for additional safeguards. And these assessment periods, these safeguards that it is proposing will cost money, will require people to conduct the assessments. Things that, so funding of systems to control and ensure appropriate application of MAID cost money, or require healthcare providers to be involved. Assessing the mental capacity of patients who are up for MAID requires people with some level of specialization to be involved in that. They will not be available for other forms of care.
So I think we have time for one more question. This question is from Rodrigo. He asks, do you see problematic connotations of the term natural death when referring to individuals affected by diseases driving them to request MAID? And how does one legally define natural death?
My hearing is not so good, so that's why I'm actually looking at the screen. I don't see it here. I would say it's late for me. It's a good question. I don't have an immediate answer to that. Is there a problematic connotation of the term natural death? It's a term that is being used in the context of medical aid in dying to often describe to some degree the reasonable foreseeable death. What's natural, what's artificial. I can see that there are some concerns about the all too easy use of the concept of natural death. But I think when we use it in the medical aid and dying context, I use it here in my presentation a couple of times. What we're talking about is that we're seeing a person whose prognosis, his life prognosis is relatively limited, who is in the process of dying, whether that's purely natural. I mean, obviously, what is natural is indeed an important question. But I think we have a sense of what we're meaning with this term, with that term in this particular context. Yeah, so I don't want to indeed use it in a stigmatizing way. I say that there is a natural good way, and then there is an artificial way of dying. That's certainly not the way in which I wanted to use it. I hope I answered to that question.
So I think it's time to draw today's seminar to a close. I just have a couple announcements to make before we thank our speaker, Trudo. Our next seminar will be on Wednesday, October 28th. This will be a panel discussion that is co-presented by the JCB, the Joint Center for Bioethics, and the Center for Vaccine Preventable Diseases. Caroline Lidstone Jones, Maxwell J. Smith, and Matthew Tunis will be discussing defining COVID-19 vaccinations, priority groups. Sign up to receive the registration link via our weekly seminar reminder email, and that is at jcb.info@utoronto.ca. Our CSB students enrolled in the CSB student seminar course, please remember to keep track of your attendance. And finally, Trudo, on behalf of all of us here today, thank you very much for your excellent presentation.
Thank you.